Dear students, I am Isra Jahan, lecturer, Department of Law, World University of Bangladesh, and this is my class lecture on the topics of intellectual property in cyberspace. Information. Information that wants to be free, especially in the open territory of cyberspace. But at the same time, an owner of such information must exercise his right. In the digital environment, it has become difficult to make a balance between owner's right on intellectual property and the right to access to information. Undoubtedly, the invention of computer network, internet, and file sharing devices such as Bluetooth, pen drive ensures the easy access to information. But this revolution ultimately leads the intellectual property such as copyright, trademark, patent under threat. This digital revolution has already thrown the music industry into chaos and movies industries also. Both of these industries have been struggling with piracy. So now it's become a challenge for the author and the owner to protect their right on intellectual property, and they will face this challenge using technological weapons. Intellectual property law that protects the result of human creative endeavors means something that you need to achieve or try hard to do something. So it refers to the creation of any original work of human mind or human intellect. Intellectual property rights are a legal concept that confers right to owners and the creator of the work for their intellectual creativity. Such rights can be granted for areas related to literature, music, invention, etc., which are used in business practices. In general, the intellectual property law offers exclusive right to the creator or inventor against any misappropriation or use of work without his or her prior permission. So, the property that is the result of thought, mind, or intellect, namely intellectual activity, and that is called intellectual property. Now, this intellectual property is usually divided into two branches: industrial property and copyright. In industrial property, there is trademark, patent, and design, and third one in trade secret, and the other one is the copyright. A trademark, that is a word, name, symbol, or device used to identify and distinguishes one goods or services and to indicate their sources. Now, copyright protect original work of authorship, including literary, municipal, dramatic, artistic, other works. Now, patent is a right given on the invention. A trade secret consists of any valuable commercial information that, if known by a competitor, would provide some benefit or advantage to the competitor. No registration or other formalities are required to create a trade secret, and trade secret endure as long as reasonable effort are made to protect their secrecy. Every nation has framed its own intellectual property laws, but on international level, it is governed by the Intellectual Property Organization, World Intellectual Property Organization. Sorry, the Paris Convention, that is for the protection of the industrial property, that is held in 1883, and the Berne Convention for the protection of literary and artistic work in 1886, with the first convention which was recognized the importance of safeguarding the intellectual property. Both these treaties are under the direct administration of the WIPO. The convention establishing the World Intellectual Property Organization concluded in Stockholm on July 4th, 14, 1967, and This convention provides the rights relating to industrial design, scientific discoveries, protection against unfair competition, literary, artistic, or scientific works, invention in all field of human endeavor, performance of performing artist, uh, phonogram, broadcast, trademark, service mark, commercial names, and designation, and other rights resulting from intellectual activity in the industrial, scientific, or literary or artistic work. So thus the term intellectual property has become to be internationally recognized as covering patent, industrial design, copyright, trademark, know-how, or confidential information. So intellectual property of whatsoever species in the nature of intangible incorporate property, the contribution of intellectual property, the economic and cultural development of country is substantial. Now, there are a number of international organizations and agencies that promote the use and the protection of this intellectual property. One of them is International Trade Organization, uh, WIPO, Berne Convention 1886, Paris Convention 1883, etc. Now, what is trademark? I'd like to give you a very short brief about what is trademark. A trademark is a symbol which is intended to indicate who is responsible for the good placed before the public. Trademarks are sometimes informally referred as brands. The law that governs trademark in Bangladesh is the Trademark Act 2009. A key aspect of this definition is the requirement that a trademark must be distinctive. That is, consumers viewing or hearing the trademark must be able to distinguish it from other trademarks. So long as this requirement is met, almost anything that is distinctive can serve as trademark. Trademark may make any form. They may consist of single letter, numeral, sound, shape, color, flavors. Like Apple has registered the three-dimensional shape of iPod as a trademark. Grameenphone has registered its logo as a trademark. So trademarks serve as an indication of source and distinguish the various goods and services in the market. Historically, the word patent has come from Latin phrase literary patent. Literally, that's mean letter patent. The word patent, at least in some of the European languages, is used in two senses. One of them is document, that is called patent, or letter of patent. The other is the content of protection that a patent refers. Invention are characteristically protected by patent, also called patent for invention. In order to be patentable, the invention must be new. It must involve an inventive step, and it must be industrially applicable. The protection that a patent for invention confers means that anyone who wishes to exploit the invention must obtain the authorization of the person who received the patent. This person called patentee or the owner of the patent. If anyone exploits the patentable invention without such authorization, he commits an illegal act. With regard to patent protection, the question arises whether the computer program can constitute an invention. Inventions are usually understood to be solution to a technological problem, which use scientific principle in the field of physics, chemistry, biology. However, so-called instruction to be human mind are not normally considered to be invention. A number of national law therefore contain an express provision excluding computer program from patent protection. And whereas a design is obtained in order to protect the aesthetic or ornamental feature of a product. So both patent and design can be acquired in respect of the same product. Simply describing, copyright means author's right on his intellect creation, such as poem, novels, music, painting, cinematography, films, etc. It consists of a bundle of multiple rights. The owner of author of a copyright protected work may use the work as he wishes and may exclude other from using it without his authorization. For example, a wrote a drama like Independence of Bangladesh, the name. Being author of this work, it has a right to reproduce it, distribute it to public, to make it display, perform, to speak alternatively. Others are not entitled to exercise these rights without his authorization. If does so, will be treated as infringement of copyright. According to Section 26 of the Copyright Act 2000, copyright has been defined, but according to Section 15 of the Copyright Act 2000, it's described copyright subsist original, literary, dramatic, music, artistic works, cinematographic works, sound recording, etc. Subscribe my YouTube channel and hit the bell icon. And don't forget to give a like.